Welcome to the Judicial Committee of the Privy Council. Before we begin today's hearing, I wish to say something about our colleague, Lord Kerr. The court learned earlier today with great sadness of the death of our former colleague, Lord Kerr of Tonaghmore, who retired as a Justice of the Supreme Court only 2 months ago at the age of 72. Justices and staff alike are shocked by the news, and we offer our deepest sympathy to Lady Kerr, her children and their families. They are all in our thoughts at this time, and we send them our condolences. Brian Kerr had the most distinguished of legal careers. As a barrister in Northern Ireland, he served as Crown Counsel for a period of 15 years. He became a High Court judge at the age of 44, at a time when the decision to serve as a judge in Northern Ireland required courage and a strong sense of duty. He served on the High Court for 11 years, and then for 5 years in the extremely demanding role of Lord Chief Justice of Northern Ireland. In 2009, he was appointed to the House of Lords as the last Lord of Appeal in Ordinary, and later that year he became one of the first Justices of the Supreme Court. Through his judgments and during hearings, Brian demonstrated his strong and instinctive sense of justice and his thoughtful and principled approach to resolving legal problems. He will never know the full extent of the impact which his considerate, good-humoured and encouraging nature had on the court, the staff of the court, and his judicial colleagues. Nor will he ever know the full extent of the impact which his judgments had on the society we serve, in Northern Ireland, in the rest of the United Kingdom, in Europe through his service as an ad hoc judge on the European Court of Human Rights, and in the many jurisdictions around the world for which the Judicial Committee of the Privy Council serves as the final court of appeal. But he has left us a legacy which will be drawn on well into the future. Brian was a deeply valued colleague, a kind and modest man of the utmost integrity, who will be deeply missed by all those who had the pleasure of knowing him. We turn now to today's appeal in the case of Das and Marchand. I'm hearing this appeal with 4 other members of the court, whom I'll introduce now. First, Lord Hodge.
Good afternoon.
Lady Black. Lord Burrows.
Good afternoon.
And Lord Hughes. We're going to be hearing first counsel for the appellant, and the submissions will be presented by Mr. Thomas Rowe, Queen's Counsel. So I turn now to Mr. Rowe.
My Lord, I'm very grateful, and I hope I might be forgiven just before I launch into my submissions for saying on my behalf, and I'm sure on behalf of many, many other members of the bar, how shocked and saddened I am and we will be to have heard the news that your Lordship has just imparted, and to echo every word of your Lordship's tribute. I'm sure there'll be lots of other opportunities for tributes to be paid to Lord Kerr, but there will be fulsome tributes not only from fellow judges, but from those who had the privilege, as I did, and colleagues, including my learned junior, Mr. Pennington Benton, did, of appearing before Lord Kerr, and indeed of getting to know him a little in the way that sometimes bench and bar can. It's a shock and a very sad occasion, not only a loss personally, but a loss to the ranks of the judiciary. And in due course, there'll be opportunities, I'm sure, for the tributes. My Lord, turning to the appeal, I should start off by saying, of course, that we recognise that this is an appeal where there are concurrent findings of fact, in the sense that the judge made a series of findings of fact adverse to the appellant, and the Court of Appeal was not prepared to depart from, to displace those facts, those findings of fact. And understandably, in those circumstances, our learned friends who represent the respondents place great emphasis in their printed case, and no doubt they'll do the same in their submissions, on the general practice of this board in not departing from concurrent findings of fact. And we recognise that we need to confront that practice squarely and explain why this is the case where the board should do so. Our overarching point is simply this, that this is one of those cases where it can be shown, and I'll endeavour to do so in the course of my I hope reasonably brief submissions, it can be shown that the judge failed to take advantage of his position as judge by properly testing the evidence against the inherent probabilities and the documents, and all in all failed to take advantage of the position that the judge had as judge presiding over the trial. And whether one says that the outcome of that is that we fall within the exception, the well-established exception to the board's practice regarding concurrent facts, which has been referred to, of course, on many occasions. We cite in the case what Lord Mance said in the Conticorp case, or whether one says, well, actually, in that sense, it makes it an error of law. Well, we cite in our printed case some examples of circumstances where, particularly in more recent times, when the courts are confronted with jurisdictions which require them to intervene only if there's an error of law, they can nevertheless look into questions of fact if it can be said that the judge simply didn't think through properly what the issues were and take advantage of the judge's position as fact finder. Whichever of those categories it is that we fall into, and I don't think it matters for my submission which it is, we do respectfully submit this is a case where the board can and should intervene and ought to do so in our circumstance, in our submission, because the circumstances are such that when one steps back from the totality of the evidence that was before the court and the judgment which the learned judge came to, one is left in our submission, and we invite the board to be left with a profound feeling of unease about whether in fact justice was done, and we submit that it wasn't. But my lord, I ought to move from generalities like that to some specifics. Can I start by just taking the board to the pleadings? And I'm conscious that of course all of this material will have been looked at already, and I'm only going to highlight what seem to us to be some of the points of particular relevance. I assume that in the usual way nowadays, most or all of your lordships and your ladyship are following this electronically, and I'll confine myself just to bundle references. The amended statement of case starts slightly oddly, I suppose, but it starts at page 252 in the bundle. If I can take your lordships and your ladyship there, first of all. It was amended at the time of the death, I think, of the second defendant, Victor Hussain, and his replacement, therefore, as a party by his personal representative. But conveniently, this document has got all the pages, whereas I think the original version, for some reason, didn't copy entirely into the bundle. And your lordships and your ladyship will see that the ownership of the property is recited, the original ownership, by the respondents at page 253, and how they came to own it, which I'll come back to in a moment in relation to the document that shows that. But what's peculiar about this statement of case as we go through it is the way in which a multiplicity of different claims are advanced. We can see at paragraph 2 what's said about the claimant and her employment by the first defendant. And then at paragraph 3, we see the first reference to the figure of $600,000, which features from time to time in the evidence and in the submissions in the case. Merely 5 days after the death of the first claimant's mother, the first defendant questioned the first claimant about the premises and indicated to her that he was willing to purchase the same for $600,000. And he goes on to allege that he offered an inducement for that. That was continually refused, but that he offered various other things, and she was grieving for the loss of her mother, which affected her mental state, and so on and so forth. Continually pestered the first claimant, it's said at the end of that paragraph, top of page 255. Then there's reference to the other respondents, the two children, who are the second and third respondent now before the board. and further inducements are pleaded. And at paragraph 5, it's pleaded that during the course of these events, the first defendant induced the second and third defendants into agreeing to a sale of the premises by holding out to them that a bank held a mortgage over the same and which was in arrears, and the property was up for sale. So it seems at that stage that what's being said, certainly as against the second, as by the second and third claimants, is that they in fact did agree to the sale, albeit it's said there this is because of the position of the bank. Then there's reference to Mr. Hussain, who was the second defendant, and there is reference to the allegation that the price was said to have had to be kept below 350 to avoid stamp duty. And then we come on at paragraph 7 to a pleading about what happened, it is said, on the occasion when the transaction was done. The claimants were each made to attend in the attorney's office individually, the second sentence of paragraph 7 on page 256. Second and third claimants told that D2 was attorney for the bank that held a mortgage. They were each being paid $30,000 out of the price to sign a one-page document. They weren't given an opportunity to read. First claimant received a check for $200,000. Claimants never presented with copies of documents signed by them. And then it goes on to talk about events afterwards, around the end of July. First claimant is said to have requested a copy of the document, being told they're all in the possession of the first defendant. Verbal abuse, it said. Then it's pleaded that the first defendant visited the property, essentially to move them out. And there's reference to that. And then we get at paragraph 10, importantly, this. Thereafter, the first claimant continued in the employ of the first defendant, whereupon she was unceremoniously terminated after she inquired of the rest of the payments due to her for the balance and owing on the agreed purchase price of $600,000. So the pleaded case there, quite plainly, is that there is an agreement that she will get paid $600,000 for the property. And it's said that the first defendant then said the value was overstated. He was reducing the price by 100,000, discounting another 60,000, and so on and so on. And then the employment of the first claimant was terminated. And at paragraph 11, to date, the claimants have only been paid the sum of $307,800 for the sale of the premises. That figure is agreed, albeit the position on the appellant's part is that that's because the final instalment was never accepted by the first claimant. She refused to accept it. But the figure of $307,800 is important for reasons I'll come back to in a bit. And there's then a reference to a letter, which I'll take the board to in a bit, of the 27th of September 2006, from the attorney, Mr. Haresh Ramnath, to the first defendant requesting the premises be reconveyed. And there's a response to that. And then we get the relief that's sought: first, an order setting aside the deed of conveyance, alternatively damages for breach of contract in the non-completion of the purchase. So as against the appellant, the claimants are riding two horses. One, we want a reconveyance, and two, alternatively, we want the damages for non-completion of the contract. There are, of course, completely inconsistent claims, but there it is. That's what they say. They want damages as against the second defendant, who was the lawyer, for fraudulent misrepresentation or inducement in effecting for the sale, and interest and an injunction prohibiting further works to the property. So that's what's said in the amended statement of claim. The defence I can take probably more briefly, my lord. That's going back in the bundle to page 47. And I don't think I need to trawl through it, but it's essentially the appellant's position there, as it has been throughout, is that most of what's said in the statement of claim is not true, and that actually this was simply an agreement prompted by the first claimant coming to him rather than vice versa, by which the property would be sold for the price that appears in the deed. And that is all explained there. The explanation as to why it is that the first claimant wanted to sell the property is given there, because she borrowed money and needed to pay it back. But other than that, I can take it fairly shortly. It's essentially a straightforward denial of all of the case that is advanced by the claimant. Now, my lord, one of our criticisms, I'll come on to these and develop them in a little while, but one of our criticisms, as I've already indicated, is that the learned judge failed to take proper account of, amongst other things, the documentary evidence. And it's helpful, perhaps, just to remind ourselves what the documentary evidence was. There was an agreed bundle of documents before the trial judge. That's at page 77 in the bundle that's before the board. And there are 7 items in that list in particular that I wanted to highlight very briefly. The first one is the deed of gift, and that's at page 81. This was described as document 1 in the list of documents. The first thing to notice on page 81, and this is perhaps an occasion when this unusual and one hopes temporary way of conducting ourselves perhaps shows some of its merits, but top right on page 81, we can see the stamp, a judge duly stamped to cover, and it might need a bit of blowing up on the screen, but we can see, I hope, under April 6, 2006, which was when this deed was presented for stamping. It's a deed, I should have said, dated the 24th of February 2006. When it was presented for stamping, it's stamped with a figure, $340,000. Which is important because that's independent evidence of the value that the mother of the first claimant, the first respondent, and the respondents themselves were prepared to put on the property on that date, on the 24th of February 2006, when she conveyed the property. She assigned the property to them, transferred it to them as a gift. So that's an important part of the background, and that's how the respondents came to be owners of this property. The next document is at page 87, and that's the deed of conveyance itself, which is dated 26th of June 2006. That's, of course, the deed that the claimants in this case were alternatively seeking either to have set aside or to have enforced. And we can see that it recites the deed of gift that we've just looked at. This is the first recital on page 88. And then it goes on to recite on the next page the contract, which by the time the deed is executed is a contract for the sale of the property for a price of $320,000. It's true, it goes on to say the receipt of which sum the vendors hereby acknowledge, which didn't in fact reflect on anybody's case what had actually happened, because as your lordships and your ladyship will have seen from the papers, in fact, $260,000 was provided at that stage, albeit further instalments were paid subsequently. Dr. Dass's case is that's because that was the money that he had available at the time in his savings, and the rest he had to make up from money that he earned as he went along, essentially. So that's the document. It's true to say that there is a curious feature of this, which was explored to some extent in evidence and is referred to in the judgment, namely that the schedule annexed to it, which I don't think appears actually at this point in the papers, though it's elsewhere in the bundle if anyone wants to look at it, bears a date which is the survey document, bears a date which is later than the document itself.
Page 90.
I'm sorry, I'm on page?
Page 90.
Yes, page 90 refers to it.
Mm-hmm. Yep.
I think the thing itself is somewhere else, but Trace, I can get that reference shortly. But for present purposes, I think for my purposes, I just make the point that we accept that there is that oddity about the deed. It was explained in the evidence on the basis that, or at least on the appellant's side and on Mr. Hussein's side, on the basis that already by the time the contract had come to be executed, it was apparent that the 340, which had originally been agreed, was a bit much because the property wasn't quite as big as it had been understood, and that's why it was reduced from 340 to 320. And the actual survey that formally confirmed that was actually done afterwards, and Mr. Hussein swapped out a page of the document, putting the survey in after the event, which he shouldn't have done, of course, but it doesn't change fundamentally our case as regards the arrangement that was reached. There's another document I ought to have gone to probably in sequence actually earlier, but let me take your lordship to it now if I may. That's document 14, which is at page 129, and that's a document dated the 8th of June 2006. And this is, as your lordships and your ladyship will see, Dr. Das signing a statement that he understands that he's been advised by Mr. Hussain that he's entitled to independent advice to look after his interests in relation to the property, because Mr. Hussain is also representing the other side of the transaction. And he signs that he's agreed to use Mr. Hussain's services. And that's the, as I say, that's the 8th of June, 2006. So, my lord, that goes back slightly in time to the 8th of June 2006. But if we go back to the date of the deed of conveyance, there's one other document which is contemporaneous on the face of it with the deed of conveyance, and that is the document which is described by the judge as document 13, because that's where it appears in this list of documents, and we can find it now at page 126. And it's, as the board will see, it's also dated, as I say, 26th of June 2006, and it's signed or purportedly signed, because the judge decided that it hadn't been signed by them, but it's purportedly signed by the 3 respondents, indicating they've been advised to do a valuation of the property, but they don't regard that it is necessary to have a valuation. And they've been told they can take a draft copy of the deed of conveyance to any other lawyer for advice, but they don't. They decline to do that. My lord, those are the documents that are signed on that date. I'm going to break off for a moment from going through the documents, if I may, just to show your lordships and your ladyship one other piece of evidence which is important and which explains to a certain extent what comes next in the documents I'm going to show the board. We're now in the, if we go to page 164, we're now in the statement of Mr. Hussain, the written statement of Mr. Hussain. He passed away, of course, by the time of the trial, but this was his witness statement prepared during his lifetime. That, I should have said, started at page 155. And he sets out at some length his explanation as to how he came to be involved in this, he says, entirely consensual transaction between the parties. But what's particularly relevant to what I want to show your lordships next is what he says at the bottom of page 164, paragraph 29. So this is after the transaction. You'll recall that the deed was dated the 26th of June 2006, so 20th of September 2006. Rosemary Marchand, the first respondent, came to my office in company with a businessman from Freeport, who I know as Premchand Rambahari, also called B. Rosemary Marchand said to me, this businessman B is now offering her $500,000 for the property. She and her children sold to Dr. Das, and she would like Dr. Das to reconvey the property to her. He says he was amazed. He reminded her of the occasion he told her to do a valuation, but the businessman said he would be willing to give her $500,000 for the property, and could I ask Dr. Das to reconvey the property to her? And he said, well, she should go and ask Dr. Das, because it's been conveyed to him now. It's his property. He couldn't do anything further. And she says at the end, Dr. Das still has a balance of $12,200 for her, which is of course common ground in the sense that it's accepted that much does remain outstanding from the purchase price, albeit we say it because that's because the respondents won't accept it. Then he goes on to say at para 30, as your lordships and your ladyship will see, during the following 2 weeks, I was inundated with calls from the businessman, the said businessman, insisting that I persuade Dr. Das rather to reconvey the property to Rosemary, who had promised to sell it to him for $500,000. And he goes on to say he learned later about an agreement. We don't need to take it from him. We can see the agreement in a few moments. And then he goes on to describe later correspondence and to deal with other aspects of his evidence, which I think need to go through as part of these submissions. Page 95 is where I want to go back in, if I may, to the documents that were before the judge. This is item 4 in the list before the judge. But I'm going through them chronologically rather than in the order they appeared in the list of documents. And we're now on the 27th of September 2006, and this is the letter before action from Mr. Ramnath on behalf of the respondents. I refer to the deed dated 26th of June 2006. I am instructed that the purchase price was $600,000, of which you have paid $307,800. Further instructed, my client never read the deed nor was shown the same, only shown where she had to sign, as you did not want her children to know you were buying same. He doesn't incidentally say at that point that there was any story about there having been a mortgage and this was a document to get money from the bank. I've received a copy of the deed which reflects a price of $320,000. It appears this price may have been placed on the deed to avoid you having to pay government tax / stamp duty. I'm instructed that you induced her to sell this property to you and threatened to terminate her employment if you didn't sell the property to you. Instructed the property is valued over $1.5 million. My client's willing to refund all monies paid by you to her and her children and meet the expense of a reconveyance. Over the page, in the absence of that agreement, litigation will follow. And that prompts the response from Dr. Das, which is at page 98, where he essentially denies all of this and explains the transaction essentially, I submit, in the same terms as his defence. The only point of difference, at the same time as his defence and his later evidence at trial, the only point of difference perhaps being that he says at that stage that the original agreement was $320,000, whereas later in his evidence, as the board will have seen, I expect, he explained that originally it was $340 and then it came down to $320, which is what went into the deed. So, my lord and my lady, those are those, as it were, the documents most immediately contemporary with the transaction itself. What I wanted to go to next was to pick up the references to Mr. Rambahari, the businessman, B, because as we've seen from the documents that we looked at so far, he plays quite an important role in all of this. And the critical document is at page 142, which is the agreement between the respondents and him. This was document 19 in the list of documents before the judge, so it was one of the things that the judge had before him. On the front page of it, we see a certification towards the top of the page. I hereby certify I've advised each of the owners, that's to say the respondents, as they now are, on the contents of these presents, and they and each of them have expressly understood and consented to these presents. And it's signed by an attorney at law. And we can see that the agreement itself is dated the 5th of February 2007, so a few months after the transaction. Sets out who the parties were, sets out the background that they were, the owners, as they described, the respondents are described, were possessed of the property. Describes recites the conveyance to our client. Describes the proceedings in the High Court, says that they're unable to finance it, and the businessman here called the investor is then referred to as having agreed to pay and bear all the expenses. And then the operative parts of the agreement, paragraph 1, as one can see, pay and discharge from time to time all expenses to be incurred for the High Court action instituted by the owners against the said Rohit Das and or Victor Hussain. And then importantly, the meat of it, or the first part of the meat of it, paragraph 2, the owners shall, in the event that they are successful in prosecuting the said High Court action, convey the said parcel of land to the investor. And in that event, the investor shall pay to the owners the further sum of $120,000, which, together with the expenses and charges paid and discharged by the investor in accordance with clause 1, shall be considered the purchase money for the said parcel of land. And what seems to be going on here, one has to read this a little carefully to work out exactly what must be going on. What seems to be going on there is an agreement that in the event that the respondents succeed in their claim, they get the conveyance set aside. That means, of course, they've got to pay back the money to Dr. Das that he's paid them, but they will get from this we say must be inferred as a matter of common sense from the document. They will get from the businessman, from B, not only that sum but a further $120,000. That seems to be the only basis on which it makes sense, and that tallies up roughly with the evidence about B being keen to buy it for $500,000. Because when you add up the $304,800, I think it was, that they'd received already from Dr. Das, the $120,000 that they get from him if they succeed, and obviously the cost that he's paying, you get approximately to about $500,000. You get to that figure more precisely if one of the other clauses comes into effect, because clause 5 deals with the possibility of there being, instead of a reconveyance, because the conveyance has been set aside, or instead of the conveyance being declared a nullity, so that in fact they owned it all along and never transferred it to Dr. Das, whichever way it is. If instead of that there is simply a financial settlement, then what's to happen? Well, that's paragraph 5. In the event that there are negotiations and Das has agreed to pay the owners a further sum as consideration for the purported conveyance to him of the said parcel of land, in other words, effectively, if there's a settlement of their claim for the money, for the damages claim, they want the balance of the 600,000, then, well, that settlement has to be not less than 292,200, which as anybody who's good at mental arithmetic will notice, is 600,000 less 300. It was 307,800. I should have said the amount that was paid by Dr. Das. So it's 600 less the amount that Dr. Das has paid. So in other words, if they get a further 292,200, in other words, if they manage to get to the position where they've got the whole of their claim for the 600, then the owner shall receive a sum not exceeding $100,000 of such settlement figure, and the difference or balance thereof shall be paid to the investor. So the upshot is, whichever way you slice it, this agreement is all built around the idea that what's going to happen, or what the investor wants to happen, is that he wants to buy the property for $500,000. That at any rate is how it seems to us, and we submit that's really the only sensible reading of it. This document plays an important part in the case, because as we'll see, there was really no, we say it's an important factor, an important reason, consider the probabilities, and it simply wasn't properly dealt with, we say, by the judge. My lord and ladies, I want to go now, and I'm conscious that time is marching on. I want to go now to the evidence briefly, if I may, and in particular to the oral evidence. I will take the written evidence, I think, largely as read. Can we plunge straight in that case to the oral evidence and to Rosemary Marchand, the first respondent's evidence? That starts at page 323 in these notes of the judge. And it's an overarching part of our submission on this appeal that her oral evidence was very unsatisfactory indeed, which is important when one considers the weight that, properly understood, it had to bear if this claim was going to succeed in our submission.
Mr. Rowe, I think I noted down wrongly the page number. What was it?
It's 323, my lord.
Oh, thank you very much.
Checking that it's not I who got it wrong, but no, it is 323. And I wanted to go first of all to one. It's perhaps a small point of detail, but it's worth mentioning in passing. 333. Towards the bottom of that page, at line 23. She's being cross-examined here. You didn't have anything written down to recount all these incidents you refer to. He's putting to her essentially that she's inventing a lot of this evidence. And she says, probably I had in a diary. You wrote in a diary. Yes. You remember earlier on I asked you, did you write down these things? I remember now. You never refer to any diary, did you? Yes, I did. When apart from just now, did you tell me that you wrote in a diary? I can't recall. I put it to you that you made up all these facts. No. And I mentioned that in passing because the counsel is right there that there wasn't any previous reference to the fact that this oral evidence that she was giving, which was, of course, in large measure highly contested, was actually supported by prior contemporaneous written material that she had available to produce. That was a detail that just emerged, apparently, in oral evidence. It was a detail that I submit should have led the judge to, at the very least, raise an eyebrow pretty severely, because surely, if that were the case, that would have been something that would have been in the documents before the judge. as it would be in any case where a person has genuinely got a contemporaneous note of something important, which is being challenged in a case. But moving on from there, my Lord, a little way down to page 335, the 600,000 that we looked at starts to emerge. Perhaps I should pick it up at the bottom of 334. Actually, I put it to you that Dr. Das entered into an agreement to purchase the property, and he paid you for it, except for the $12,000. Question: what? That should be question. That goes on. Question: why didn't you accept the $12,000? Because I was not accepting final payment when I realized what was going on. Not true. You know why? Because you signed a document saying that you would have to pay Mr. Rambahari $100,000 if you settle the matter. Not true. Document shown. That's what we looked at earlier. I put it to you that the transaction you entered into voluntarily. Not true. No, that is not true. Did you not give instructions to your lawyer to have Dr. Das pay you $600,000? Which lawyer? No. You ever discussed $600,000 with Dr. Das? I can't recall. I put it to you that Dr. Das paid you the agreed price. That is not true. There was then a break till the next day. The subject is picked up again immediately, the next page, 336. Do you recall on the last occasion talk about a $600,000? Yes. What was that all about? That was an offer. We were given life plus life interest to stay on the property, and Dr. Das would use a downstairs as his office. What you mean when you say offer? That was the offer the bank said for the mortgage. The bank offered that. How do you know this? That is what we were told by Victor Hussain. When was that? The day we went for the checks. You have that in your witness statement. I don't recall. So this is the claimant's evidence about the $600,000 in circumstances where her pleaded case, as we've seen, and indeed her letter before action, both assert that there was actually an agreement reached, albeit it said reached under pressure and because of pressure that was being put on her by Dr. Das, and it is said because of her medical condition, although that's not something that was accepted at trial by Dr. Das. But it said that in those circumstances there was actually an agreement, and yet here she is giving this utterly incoherent account of that in the course of her evidence, which, as I say, is important when one comes to consider, we submit, how the judge ought to have analysed the case. Then questioning moves on to the subject of the agreement with the investor. The agreement you made with Mr. Marchand, you recall that, it's line 20. Yes, we did sign an agreement as he is the investor. Does the $600,000 tie in with that agreement in any way? No, it does not. If you were to receive that, would you be satisfied that this was a legitimate transaction? No, I would not accept no money. What would satisfy you in your mind? I would like the deed to be set aside to get back my property. To be sold to Mr. Marchand? I am not selling him any property. So what about the agreement? It was just set up so he can pay our fees. In exchange for what? Nothing. Why would he do that? I cannot answer for Mr. Rambahari. So he is paying your fees in exchange for nothing. Yes. So, my Lord, we draw attention to that as a, we say, pretty incoherent account by the first respondent of the agreement that she had reached and indeed been advised about, as we saw from the certificate independently, that she had reached with B, which was explicitly on the basis that the whole purpose of the enterprise now was that she would sue, and she would either get a money sum topping it up to $600,000 from Dr. Das, or she would get the property back, but then convey it on to B, albeit for more money. But that's what she says about all of that in her evidence.
One of the points that might be made, Mr. Rose, is that this witness, from what we're told by the judge about her mental state, is one whose evidence will have required particularly careful assessment in a way which may not be as easy for us to do simply reading the transcript as it was for the judge himself.
I accept, my Lord, of course I accept. We have to accept that inevitably, as in any appeal, the judge was in a better position than the present court is to assess matters like that. But we put our appeal squarely on the fact that on the basis that the importance which appellate courts, well, the importance which judges and therefore appellate courts also nowadays place on matters like demeanour, particularly in a commercial case where there are documents, is of course very much less than perhaps it once was, or at least was once thought to be. We rely upon a lot of material that the lordships will be very familiar with about how actually nowadays the proper approach is considered to be to look at the inherent probabilities, to look at the contemporaneous documentation, and to view it all through that lens rather than trying to make sense by looking at the demeanour of the witness in the witness box of how things are. But of course, I accept it's a point against us that the judge saw her and your lordships didn't.
Well, the only point really was in my mind was that you're taking us quite properly to inconsistencies in her evidence and aspects of her evidence which might be thought to be unreliable or incredible. But the judge tells us that she's not like an ordinary witness. She is a person with particular mental problems.
Yes.
And that makes her, the assessment of her evidence simply on the basis of a transcript, particularly difficult.
Well, but I accept that, my lord, but I think I would turn it around this way. Our case is that when you look at the nature of the allegations that were being made against Dr. Das, and indeed against the late Mr. Hussain, and when you look at all the contemporaneous documents, which were the contemporaneous material that was reliable, this was a case which depended upon the uncorroborated oral evidence of the claimants, and so actually the fact that the claimant is a person whose evidence you need to treat with great caution is a point in our favour rather than a point against us. I see. Because it makes it even more stark how difficult actually it ought to have been for the claimant to succeed in this case. But of course, I accept that your lordships have a disadvantage vis-a-vis the judge in relation to things that the judge saw because he saw the witness in the flesh, and your lordships and your ladyship don't have that opportunity because we don't have appeal as a rerun. But as I say, that's not, I submit, in any way a fatal objection. If anything, it goes in our favour. I mean, one of the points I wanted to make in connection with the overall implausibility of the claimant's case, which is what I'll come on to submit, is the prevailing background factor in this case, is what one sees in the evidence that's put forward as to the circumstances in which the documents themselves came to be signed. And I said I'd take the witness statements largely as read. Can I just show your lordships one of them? And that's page 169. This is Rehana Ramgobin, the legal secretary. And she gave evidence essentially corroborating what the late Mr. Hussain had said in his witness statement about the circumstances on the 26th of June, because your lordships will recall that the claimant's case was that this was all essentially a trick perpetrated on them, albeit they'd been pressured into selling. It appears they might have agreed to sell, but then when it came to it, they were told this is actually nothing to do with the sale. This is some document to do with the bank, and you've got to sign here. But she gives evidence there that in that statement that actually she typed it up, and paragraph 10, in the presence of Mr. Hussain, this is page 171, and Rosemary Marchand, I read each paragraph of Rosemary Marchand while Mr. Hussain explained it to her. Mr. Hussain informed her of her right to have another lawyer to review the deed, but she said it wasn't necessary. Typed out a statement to that effect. The statement I typed on the computer while Mr. Hussain called it out from a manuscript. I then printed the deed and statement, etc., etc., showed her where to sign. And she gave oral evidence essentially along those lines. That's at 346, as for your lordship's notes, where you can see that that's where that begins. And so essentially it's along those lines. The one point that seems to have been picked up, and I noticed that the respondents run with this, emphasize this quite heavily in their case, is an answer that she gave at line 20 on page 349, In particular, ma'am, it states that they were selling the property to Dr. Das for 320,000. Yes, and you made the deed for 340,000. Yes, but you made this before or shortly after. I can't remember if I changed the consideration. So we established you made it for 340. So why is the amount different from the deed to the instructions? I don't know. As far as I can make out, there's no discrepancy on the documents. The deed says 320, and the documents also say 320. What seems to have given rise to the suggestion of 340 is some oral evidence from the legal secretary to the effect that she had been asked to write out 340. But in fact, we know from the evidence of Dr. Das that the respondent, the claimant's, sorry, the defendant's case, the appellant's case was, as I've described it, 340 was originally agreed, but it came down to 320 before the deed was signed. So that's a fairly brief trip through some of the contemporaneous material. Why is it then, to turn to the substance of the appeal, why is it then that we say that this is one of those cases where the judge simply failed to take advantage of the opportunity given to him by virtue of being judge, by failing to assess the evidence properly in the light of the inherent probabilities and the and likelihoods and the contemporaneous evidence? Well, our first point in that regard is this, and we've grouped them in our printed case into broadly 3 points, and I'll follow more or less roughly the same scheme, although in a case like this, it's perhaps a matter of chance really as to exactly how one follows it through. But the first broad point is this: we say the starting point.
Can I just interrupt you just
yes,
before you, just in case I've misunderstood? If 320 appeared on the deed, I don't at the moment understand how 320 would have appeared on a deed signed in June when the price was reduced as a result of a survey in July.
Because I think the evidence was, I'll dig out the references to this, my lord, but I think the evidence was that the survey merely confirmed what had already been established.
I think Lord Hughes has a question.
Yes.
We can't hear you.
Oh, I'm sorry.
That's all right now.
Yes, I'd like some help on that, Mr. Rowe, because you're quite right. That's what the lawyer said in his statement. But as far as I can see, though of course I may have got it wrong, it's not what the doctor says. The lawyer says that the doctor at some stage told him that he'd done an amateur measurement sometime before the day of the deed was signed, and come up with a figure which reduced the measurement to what is eventually stated in the document. That's what the lawyer says, and that the eventual survey on the early in July simply confirmed what the doctor had done as an amateur. But I couldn't find anywhere where the doctor said that he'd done that. Have I missed it?
Possibly, my lord. Let me just give me a moment just to remind myself on this point. No, I was well. It's dealt with at paragraph 9 in the defence, which is page 38.
Mm-hmm. I think I was thinking,
Yeah.
of page 238,
Yeah.
paragraph 20.
Well, no, yes, I see that. What of course isn't stated expressly there is the chronology. But of course it doesn't necessarily. It doesn't. I agree that the survey itself is dated later.
He says, doesn't he, that he went with the surveyor, told him what the measurement was.
Paragraph 20, yes. Yeah, but that doesn't give you is the date. It doesn't. The critical point from the claimant's point of view is to show that the date on which the knowledge that the price had to be reduced was only after the deed was signed.
Well, that's quite right. But the trouble with that is that the surveyor, we know from the surveyor that he didn't go until July.
well, the survey itself is dated that date. Yeah. Let me. I'm grateful for the point being highlighted. It's a point I need to deal with, and I'll come back on that if I may in due course. So, my lord, the overarching point I was making in relation to this was this one, really, is our first point about why the judge, we submit, went wrong in the way that he assessed the evidence in the case. That the starting point, I respectfully submit, ought to have been the inherent likelihood of the transaction coming about in the way in which the respondents variously, as it happens, in fact, alleged that it had done, as opposed to it being simply a transaction which was the result of an agreement between the parties to conduct the transaction. It required the judge to accept that Dr. Das, a medical doctor of many years standing, with no reason, as far as anybody knew, to behave in this extraordinary fashion, would conspire with Mr. Hussain, who was a lawyer in good standing, effectively to defraud in some fashion the claimants by somehow procuring them by this odd variety of means, pressure on the one hand, and then an outright trick, getting them to sign a document that simply wasn't the document they had been told they were signing, to forge other documents, because it was said that the other documents we looked at were simply false documents. That's to say, the 8th of July, Dr. Das acknowledging to Mr. Hussain that he's happy for him to act for both sides of the transaction, and the 26th of June, 8th of June, I should have said, and the 26th of June, contemporary with the deed, saying that they were content with the way things had been done and they didn't want a further valuation, to forge those documents and put forged documents in evidence, to conspire effectively with Mr. Hussain's legal secretary for her to give perjured evidence about what she had seen, when in fact things had been done quite differently, all for the purposes of securing a transfer of this property for the price of $320,000 in circumstances where the only evidence that was accepted by the judge, he rejected a rather outlandish valuation at 1.5 million. The only evidence of value was 340,000, which was what the claimant herself had put on it when she had the document stamped when she got it from her late mother. And that ought to have struck the judge pretty firmly at the outset, we respectfully submit, as a pretty tall order. Not to say that it couldn't be established, but it was a pretty tall order, and it required some reasonably cogent evidence to establish it. And we rely, as we say in our case, on it being, we say they're settled law. Perhaps that's a slight overstatement to put it as a pure proposition of law, because ultimately these questions of fact are all questions of fact. But we say it's a settled principle that the more improbable an event is, the more cogent the evidence is that ought to be adduced, if one is to find on the balance of probabilities, which of course remains the standard throughout, that it is something that actually happened. And of course there are exceptions to that, where you have an already dishonest defendant. That's been pointed out in various cases, recently in a lot of the what might collectively call the Russian cases in London, involving Russian banks and Russian individuals, it's been said, well, that doesn't cut much if you've got prior dishonesty. But in a case like this, where there's nothing like that, that's essentially the principle. And the judge shows no sign of recognizing that at all in our respectful submission. That the way in which the judgment proceeds is simply to address, well, inconsistencies here, inconsistencies there, to treat it, as we say in our printed case, really as a case of, well, he says this and she says that. And there's no systematic acceptance by the judge at the outset of the judgment, as there ought to have been in our respectful submission, that what he was being asked to accept was a highly improbable story. And of course, it was an improbable story that was also flatly inconsistent with the documents, because the claimants had to explain how it was that that they had come to sign all of these documents. I mean, I suppose the two go together in the sense that we say they have to come up with the story in order to explain how they came up with how they signed the documents. But on the face of it, the documents are all dead against the claimants. And the difficulty with the judge's judgment is that the then judge simply fails to, and this is really our first point, simply fails to deal with that. The only area of the judgment at all where there is any real reference to inherent probabilities is paragraph 127, which is at page 454.
Did we say this is an error of law? Evidently, where the onus of proof lies and what the standard of proof is are matters of law, but you wouldn't normally begin, for example, in a criminal trial by directing the jury to take as a starting point the inherent improbability that the doctor and the solicitor had defrauded the alleged victim.
I agree, my lord, that one might not expect a trial judge so to direct a jury, but the error of law comes about because this feeds into the question, which is critical to the which is the premise of the respondent's point about concurrent findings of fact, that the judge had, as Lord Mance put it, taken proper advantage of having heard and seen the witnesses, and has, in that connection, tested their evidence by reference to a correct understanding of the issues against the background of the material available and the inherent probabilities. And the question that's what the board has said in Conticorp and on other occasions is the underlying premise. If you've got, I agree, if you've got that in place, if you've got a judge who goes about the task in that way, takes proper advantage of having heard and see the witnesses, tests the evidence, etc., keeps in mind the material available by way of background that's documentary or otherwise it's incontroverted, and the inherent probabilities, then there's a severe limit to the extent to which any appellate court, let alone the board on a further appeal, can get involved in whether the judge got it right as a matter of fact. But our attack is at the overall approach of the judge. So perhaps I would accept that merely couched on its own, if that were my only point, to say discreetly simply, well, the judge didn't recite that here is the burden of proof, I agree that wouldn't do the trick. But one's looking at holistically at the judgment and saying, is this a case where the judge really took advantage of his position, tested the evidence in the right way, and a telling indication of the fact that we submit the learned judge didn't is the fact that there's no recognition at all in the judgment we would submit of the proposition that this was actually a pretty extraordinary case that was being put forward by the claimant, and it therefore depended very heavily upon what the judge needed to remind himself of that, and he needed to be aware that their case had a lot to establish. What the judge actually does do by reference to inherent probabilities is very brief, and it's at page 400 and starts at page 453 actually with determination of the issues. This is after the judge has gone through certain discrepancies which largely cut both ways. He says at 127, it's difficult to understand why a woman obviously financial little means, who is not a healthy person, etc., would essentially would agree to sell the premises where she had lived since she was 10 years old. She was 52, and which had recently been given to her by her mother just 3 months or so prior to her mother's death. It seems more likely than not that it would have been because of the apprehension of some impending doom which would have forced her to sell and move out of the premises. The two explanations for sale were given, and the judge recites them: the alleged impending sale by the bank, or because of harassment and threats meted out to her because of a loan. That was what Dr. Das explained had been said to him. Which version is more probable? And the judge goes on to say, well, essentially he thinks that the latter version, that's to say, end of para 128. The first named defendant, the first named claimant's employer and doctor, being aware of the death of the first named claimant's mother and her mental state, came up with a ploy to get the premises from her after she refused to accept his offer to purchase the premises. To my mind, the latter version, in light of all of the circumstances of the case and the evidence then, seems to be the more probable explanation for the sale. Well, that's essentially it as far as the judge's reasoning in relation to probabilities is concerned, and that we respectfully submit that's wholly inadequate. I think question is impending.
Did the counsel for Dr. Das explore with Naomi the allegation which Dr. Das made that the reason for the sale was that she had stolen a necklace and her mother had borrowed money? I don't think so.
No.
Did the counsel for Dr. Das challenge the evidence of the children that they understood that they were receiving the free proceeds after the payment of a bank mortgage?
My Lord, I think that was challenged. I'm just looking to check that I'm not getting that wrong. Naomi Marchand's evidence starts at 304.
Well, if you want to come back to it,
yeah, let me come back. I'll add that to my list, which is
I did notice
Mr. Benton's list of things references to remind me of.
I did notice that there was no challenge to Naomi about the story of the stolen necklace, but I can't say I've been able to check the bank mortgage point yet.
Yeah, no, I agree, and that plainly I accept that's clearly there ought to have been. That's a failing on the part of the way the case was presented at trial, but because it was plainly was Dr. Das's case that's what had happened. So, my lords, my lady, I was just saying that the learned judge doesn't really show any recognition of the fundamental unlikelihood of what's being proposed and the seriousness of what's being alleged and the seriousness of it. These are really, really serious findings of dishonesty, essentially conspiracy to defraud, perjured evidence being put forward, purloining persuading the legal secretary effectively to give perjured evidence. This is all a very, very serious matter, and none of that is properly recognised by the learned judge. And it's not good enough in my submission simply to say, as the judge does at 127, well, it's not probable that the first claimant and her children would have wanted to sell the property. And for a start, why is that improbable? Why is it improbable that having in effect inherited a property, having been gifted it shortly before the passing away of their mother, they decided to sell up their childhood home? Why is that implausible? And of course, it doesn't. There's no explanation, as far as one can see, for why not only is it implausible what the defendants are alleged to have done, but why would they do it? What was the advantage to them? Because there was no evidence that they were going to make a lot of money out of doing this. Because the evidence was that the property was worth 340 a few months earlier. So, broadly speaking, my lord, that's our first point. It's simply a fundamental error we submit in the way in which the judge went about the matter. Secondly, we say two things, perhaps under this head, which we call point 2 in our printed case. The judge didn't really take account of the fact that the claims themselves were inconsistent with each other. And he ignored his rejection of the contractual claim. The claims were inconsistent with each other for reasons which are almost too obvious to require stating. At the same time, the claimants were saying we were persuaded into selling the property, and we didn't actually sell the property at all because we didn't actually sign the document we were tricked into signing, it effectively non-est facto, although it wasn't put in those terms. There's at the very least a tension between those two, though I accept that they could, I suppose, be said to be part of the same continuum of fact, but they're still quite different things. But at the same time, they were also advancing the claim that they had agreed to sell for 600,000 and they wanted the balance. That ought to have set alarm bells ringing very loudly in the judge's mind, in our respectful submission. That's an extraordinary way to run a claim. And it had what it had written all over it was essentially opportunism, that the claimants were seeking to take advantage of the situation so as to profit. And that ought to have increased the scrutiny that their evidence faced, increased the extent to which their oral evidence came under very, very close scrutiny. But the judge didn't do that. The judge didn't also, as I say, ignored the fact that he himself rejected the contractual claim. The judge said that in the passage, just the passage we just looked at, on page 453, bottom of the page. At this point, it's important to note this court does not believe that there was ever any agreement reached for the sale of the premises for $600,000 with a life interest to the claimants or any one of them, together with free medical treatment, etc., etc. The issue, therefore, is whether they were tricked into selling the premises because of this allegation of there being a mortgage on the premises. But the claimant's case, as we've seen, had squarely been that there had been an agreement, albeit they said they'd been persuaded against their better judgment in reaching it, but they said there was an agreement, and indeed they were suing on it. So that ought to have focused the judge's attention very clearly on the question whether or not the oral evidence of the claimants was sufficient to support what they were alleging. And it's in that context that I think that's what I was alluding to when I was answering or trying to answer my lord your question, your lordship's question earlier about the judge's advantage. Well, it's true the judge had the advantage of seeing the witnesses in the flesh, but there's no real suggestion in the judgment that there is something about the demeanour of the first claimant giving her evidence which somehow redeems the fact that when she is pressed with demonstrably clear and incontestable facts, she essentially talks nonsense about them. Now, it may be that she talks nonsense because she's lying. It may be she talks nonsense because her memory is terrible. It may be that her medical condition in some way affects her. It doesn't matter for the purposes of the judge's task in establishing whether or not the claimants have made out what they have set out to prove. In our respectful submission, they plainly don't do so, and the learned judge just doesn't deal with that at all. Doesn't seem to have any reference in the judgment to the implications of either the inconsistencies in the case that's being put, or the rejection of the contractual claim for what needs to be proved, and then for the difficulties that in fact follow from the way in which the claimant gives, in particular, her evidence. So, my lord, however one cuts this, whether one says this is an error of law in the sense of the English cases we referred to, or that it's within the Conti Corp case where the whole premise isn't made out because the judge hasn't properly taken advantage of his position as the judge, we submit that's a further factor that shows that this is a decision that simply isn't safe, and that the board ought to set aside. My lord, the third point is in connection with this agreement with Mr. Rambahari, which is a very peculiar feature of the case, which ought, we would respectfully submit, on any sensible view of the evidence, to have been prominent in the judgment as a really pretty extraordinary factor, because it provides, in complete contrast to the defendants, for whom there is no motive to do what they're alleged to have done, it provides a very clear motive for the claimants to act in the way that they are acting. Here they are, having sold the property to Dr. Das for $320,000, having been paid almost all of the price, but not the last instalment. When Mr. Rambahari comes along and says, "Well, I want to take it off you for more," and he enters into an agreement, which we looked at earlier, which shows how that's going to work. So all they have to do is go along with this, turn up, allege that they didn't in fact sign the documents, allege that they were pressurized into signing them, allege alternatively, perhaps slightly cheekily, but alternatively that they actually are suing on the contract and they want the rest of their money. Either way, as we saw in the document, they don't have to do anything other than that, because he will carry the whole burden of the exercise. And either they fail, in which case they don't have to pay any of the costs because he'll cover all of that, or they succeed and they get more money for the property. So that ought to have been in the judge's mind as a really pretty powerful factor to place the evidence of the claimants under the most intense scrutiny as to whether, notwithstanding the general unlikelihood of what it was they were alleging, it could, even if the judge was persuaded that it was generally likely that this is what might have happened, as whether their evidence could sustain it, knowing that they had a motive to lie. And again, we see essentially none of that in the judgment, my lord. It's simply overlooked and not treated in any way as a relevant factor. There's a subsidiary point to be made in relation to the document, which is that, as we saw in the evidence that I took the board through earlier on from the first claimant, she gave utterly unreliable evidence in relation to that very document. She affected not to understand what it was. She initially made denials in relation to it, all in circumstances where the document itself is both perfectly clear and on its face bears the certificate of the lawyer that he'd given advice. I think Lord Hughes has a question.
I was only going to take you up, Mr. Rowe, on the suggestion that the funding agreement was perfectly clear.
Oddly enough, my lord, as I said that, I wondered whether, on reflection, that was entirely right. Let me rephrase that. It perfectly clearly exists. Yes. And it's clear that she signed it, and it's clear that it says that she was advised about it. I agree. As a matter of construction, as to what it means, I can't say that. And I mean,
the obvious hole in it is, as you've pointed out, that it says nothing at all about who's to pay back Dr. Dat if the action succeeds. And I suppose what you're saying is she must have understood that, but her evidence rather suggests, I just wondered if her evidence left open the possibility that she just might have signed a document that she didn't fully understand.
Of course, her evidence leaves open that possibility, my lord, but as a matter of construction of the document, it must be right that the explanation that I gave is correct, because otherwise it's an absolutely extraordinary document. I mean, she's agreeing to bring about a situation where she has to pay back $307,800, and then she gets 120. So that's a pretty bad deal. So not even a not entirely clued up litigant would have entered into that arrangement. But the important point for our purpose is, as I say, that it provides a powerful motive for the claimants to do whatever they need to do in order to try and get home on this claim and say whatever they need to say, even if that means accusing people of unblemished character of the most appalling skullduggery, and thereby trashing their reputations in the courts. And secondly, it provides an illustration, as I say, of the fundamental difficulties in the evidence of the claimant, the unreliability of it, and that unreliability, as I say, I don't press that on the board because I invite the board to say, oh well, look, she gave unreliable evidence, therefore her claim should fail, simply because it was less attractive. I appreciate that a more sophisticated analysis than that is called for. My point is simply that because of the structure of the case and because of the probabilities and the documents, the whole weight of the claimant's case rested upon the claimant's oral evidence, and therefore the fact that it wasn't much good reflects the weakness of that case, and that should have been accepted by the judge, and it simply wasn't. So, my lord, essentially those are our submissions in relation to the reasons why we say the judge failed to take proper advantage of his position. Could I, looking at the time, my lord, suggest this? I know sometimes your lordships in any event like to have a very short break at some point, even during a short session, and I've got a couple of things to look up. May I take perhaps 3 or 4 minutes and then resume and finish the rest of my time just answering those specific points of detail that your lordships put to me?
Yes, certainly. We'll give you time to confer with your junior, who has no doubt been beavering away.
I hope so.
So we'll adjourn. If 5 minutes will be sufficient time for you, Mr. Rowe.
I'm very grateful, my lord.
In that case, we'll simply switch off we'll mute ourselves and stop our video feed for 5 minutes.
I'll do the same.
And then we'll resume.
Thank you.
I think we're all ready to resume now, Mr. Rowe.
My lord, thank you. I'm grateful for that brief opportunity to come up with some references. My lord, I think there are two things I needed to pick up on that were left over from my submissions earlier. The first was in relation to the question of the survey and Dr. Dass's evidence in relation to that. I think your lordships and your lordship have the point that Mr. Hussain distinctly says what your lordship have in mind what Mr. Hussain says in his evidence. So far as references are concerned to that, they're probably already there, but it's page 158, paragraph 11, which is Mr. Hussain talking about Dr. Dash requesting a search being done. And it runs through then to paragraph 18. Dr. Dash reminded me there and then, in the presence of Rosemary Marchand, this is when they're on the 26th of June, that he had gone onto the land and discovered that it was not what the vendor's deed said it was. That is to say, 12,600 square feet was not true. He then said that if the official licensed surveyor found the same of 12,254 square feet, he would not be paying the price of 340 as agreed by the vendors, but would deduct a sum commensurate with a lesser amount of footage. I suggested to them that we should wait until the licensed surveyor officially completes the survey. Rosemary Marchand said if the land footage is less than what her deed had said, she would agree with Dr. Dash for a lesser selling price. Paragraph 19, Rosemary insisted on meeting the deadline for the execution of the deed of conveyance on the 26th of June, requested I put Dr. Dass's unofficial survey measurement of 12,254 in the deed I was preparing, although I told the surveyor we were visiting the site. I told her the surveyor was visiting the site on the 6th of July 2006. She, however, said she and her children and the other owners were insisting that the sale comply with the deadline date of the 26th of June as they were in great need of money. And then Mr. Hussain explains how he subsequently put the survey plan into the, when the official survey plan, as he calls it, came through, he put that into the deed retroactively, as it were. I agree that account of things doesn't itself appear in Dr. Dass's own witness statement, which we looked at earlier, which is in rather briefer form. But in his oral evidence, this is touched on at page 359 when he's being cross-examined. And we can see at line 11, there's reference to that being put to him. The price discussed before Mr. Hussain was $600,000. Again, reference to the 600, which your lordships and lordship have heard what I said about that. So when you signed the deed, what was the sum? 320,916, and you sign on the 26th of June on the same day. Is it true you dropped her and her children at Victor Hussain's office? Yes, on the way home from lunch. The survey was done after the signing. Yes. You agree that the reason you adjusted the price was because of the cost of the survey and the reduction in the size of land, correct? Yes. How much did you pay for the survey? 4,000. How did you arrive at a deduction of 16,000? Simple mathematical equation. I put it to you, your maths is wrong. You can't say that. Did Mr. Hussain ask Ms. Marchand if she wanted a sale agreement when you went to Mr. Hussain's office, etc., etc., and then it moves off that topic. What doesn't seem to have happened is that the point about the timings was explored with Dr. Dass either. So it wasn't dealt with very satisfactory on all sides at trial. What Dr. Dass doesn't get from that cross-examination is clearly being put to him what no doubt will be being said by the respondents very shortly, which is that, well, this can't be right because look at the dates. The account that Mr. Hussain gives in his statement makes sense in terms of explaining the dates in the documents, and it doesn't seem to be put straight to Dr. Das that that account is wrong. Although I agree, that's not as favourable to me as being able to say positively that he himself adopts that account. But that was the case that was put effectively jointly by the defendants as to how this came about. And I think I'm told it's in his defence as well. I'll just find that and see if yeah. Oh, of course, yes. I'm being reminded off stage, as it were, that yes, paragraph 9 of the defence. So that's that. And Lord Hodge asked about the children and what was put to them. I think I'd accepted that it wasn't put to Naomi that the reason for the whole thing was her difficulty in connection with the necklace. What was said about the signing? Well, can we pick it up at page 310, which is in the cross-examination of Naomi Marchand? According to your evidence, you're saying the three of you went into his office one by one. Yes, I put it to you that is not so at all, not true. When you went to the office, it was yourself and Nicholas who went there on 26th of June. No, that's not true. And you both went to his office together. Do you recall Victor Hussain advising both of you that you should have another lawyer read out the deed for you? No, I'm suggesting that happened. I'm also suggesting that Mr. Hussain advised you to consider getting an updated valuation report. No. Both you and your brother declined, and you also declined having an updated valuation. He showed both of you individual managers' checks. Can you repeat that? Don't understand. Did you show you a check, etc.? And you signed a blank page. Yes. He at that point, Naomi is being cross-examined along a line which is consistent with the defendant's case. It's put to them they went together. It's clear they're being challenged on their case about having simply been given a blank piece of paper to sign along the lines of their case. It appears to be the case that it's not actually put to them in terms, this whole story about you having been told that this was a document in order to extract money deriving from the bank's sale of the property is a pack of lies, but they're plainly being challenged on it, and it couldn't be said that they had an opportunity to. They couldn't complain about their evidence not being properly tested on that point. That's as regards Naomi, and the documents for. So I'm right on 230, so I need to stop. The documents for Nicholas are at page 317 and 318, where the same, or rather the reference in the notes is at those pages.
Well, Mr. Rowe, can we look please at page 231?
Yep.
Forgive me. Because if you read paragraph 5 to 7 of Nicholas's witness statement, he makes a clear allegation that Dr. Das told him that his grandmother had taken out a mortgage, had stopped paying, and the bank had to sell the property. That his sister told him that she'd been told the same story, and they'd no reason to believe him. And the next morning, Dr. Das telephoned to say that the bank had got a buyer for the property, and he was to receive a payment of the balance of the sale. None of that was directly challenged.
No, I agree. It was. I don't think, unless I missed something which I can retrieve before I make my reply. I think the answer is yes. That wasn't directly challenged. But all I can say is what was being put broadly was the case about having attended the office on the 26th and signed a deed and having been explained to them, which is flatly inconsistent with that.
Thank you,
My lord, I think my time's up, and in any event, those are my submissions.
Thank you very much, Mr. Rowe. I think we will adjourn to consider what we've heard so far. Thank you very much. I think we're now ready to resume. Mr. Rowe, we've considered carefully your submissions, which we're most grateful. Having considered them, we don't feel it necessary to hear from Mr. Bahari Lal in reply. We'll issue a written judgment in due course.
Before you adjourn, may I
Yes,
just add one matter?
yes, yes, Mr.
I
Bahari
was
Lal.
quite surprised to hear my lord's news at the very beginning of this appeal.
Yes,
May I say that as a member of the Trinidad and Tobago Bar and the English Bar, I have been appearing in appeals before the board since 2005. And in all of the appeals I have appeared in, I have come across Lord Kerr in most of them since that time. He's been a tremendous supporter in appeals to the board.
yes.
And I can say with complete certainty and accuracy that in all of the appeals I've appeared in, whether they are easy or hard, I found that in the harder appeals he was kind, and the harder the appeal it was, he was even kinder. And that is something that I can say, and I know Mr. Rowe would share. I think in the first appeal I did with Mr. Rowe, we were both leading juniors, and Lord Kerr was in the chair, and I'm sure he shares that experience. Can I say that I'm extremely saddened to hear that he has passed away. He's been a tremendous inspiration to junior barristers and leading barristers, in particular barristers from the minority community like myself, to aspire better and further. And I'm very sad to hear that.
Thank you very much, Mr. Bahari Lal. Your remarks are greatly appreciated, as were those made by Mr. Rowe at the beginning of the hearing. The court will now adjourn.
Thank you.